safety and welfare for those around us. There's this writ of Quo Warranto really like nails it down. And I'm just going to do a quick screen share let me pull this up real quick. Sorry, I've got Black Law's dictionary here, but I've also got, I'm going to show you the legal dictionary as well. Hang on. Sorry, there's a little pause here in the conversation, but give me just a moment, please.
Well, then I'll take an opportunity to say thank you, thank you, thank you a million times. Thank you.
Oh, you're welcome. My pleasure.
Yeah. And while you're doing that, I want to make a comment on law dictionaries.
Yeah.
To use a law dictionary appropriately, you should use the one that was published prior to the law that you're referring to, or the period of time, or whatever it is you're referring to. Sometimes you have to go back to Bouvier's for really old stuff, or you have to go to Black's First or Second. I used to have a complete library of all the law dictionaries about Black's Ninth. And that's what you really have to have. You have to know, like in '98, when Clinton said, well, it depends on what the meaning of the word is, I grabbed my Black Six because that was current at that time and looked it up. And sure enough, the little word was in there with a legal definition. And once I saw that, I says, well, that silver-tongued little bastard. Basically, they were pretty sharp on the law, those guys, both of them. So just a little word to the wise on that. So don't just cite from Black Sixth or Black's Second or something like that. You have to know what the time period was of the law that you're dealing with, or what period you're dealing with in terms of litigation, to use the right dictionary. And most of them are available at the law library.
Thank you. Thank you. Words to the wise.
Yeah.
Absolutely. Okay, so let me just do a quick screen share here. Oh, may I be, yes, thank you, Jeannie, appreciate you. Okay, let's see now. Fourth time's the charm, I'm sure. All right, let's see. All right, here we go. Okay, so Black Law's dictionary. By what right, as Ron Kelly was stating, an old English practice, a writ in nature of a writ of a right for a king against him who claimed or usurped any office, franchise, or what? Liberty. To inquire about authority, he supported his claim. In order to determine the right, it may also lay in case of a non-user or long neglect of a franchise or misuser or abuse of it. Being a writ commanding the defendant to show by what warrant he exercises such a franchise, having never had any grant of it, or having forfeited it by neglect or abuse. In England, generally throughout the United States, this writ has given place to an information in the nature of a Quo Warranto, which in form of a criminal proceeding is in effect a civil remedy similar to the old writ, and is the method now usually employed for trying the title to coordinate or other franchise or to a public or corporate office. So essentially what they're saying is, if somebody's trying to extend their authority, and a lot of people interpret property as just, their material goods, right? But they try to extend their authority onto your material goods or onto your actual physical body. You have to ask them, where do they have the first claim on your, if they can provide a proof of claim, right, that they have first claim over your body, then you will bend the knee to them. And there's a specific structure and how to make this work. There's a way in which you actually organize the paperwork, and I'm going to get into that in a second. But the first thing is to understand the power of the Quo Warranto. So let's go over to the legal definition here. And let's go through this, and you're going to enjoy this quite a bit. An Old English practice, the writ of Quo Warranto is an order issued by the authority of the king. Was one of the most ancient and important writs. It has not, however, been used for centuries, since the procedure and effect of a judgment were so impractical. Or is it? Currently, the former procedure has been replaced by information in the nature of a Quo Warranto, an extraordinary remedy by which a prosecuting attorney who represents the public at large challenges someone who has usurped a public office, or someone who, through abuse or neglect, has forfeited an office to which she was entitled. In spite of the fact that the remedy of Quo Warranto is pursued by a prosecuting attorney in a majority of jurisdictions, it is ordinarily regarded as a civil rather than a criminal action. Quo Warranto is often the only proper legal remedy. However, the legislature can enact legislation and provide other forms of relief. Now, statutes describing Quo Warranto usually indicate where it's appropriate. Ordinarily, it is proper to try the issue of whether public office or authority is being abused. For example, it might be used to challenge an unauthorized practice of a profession, such as law or medicine. In such situations, a challenge is an assertion that the defendant is not qualified to hold the position she claims. A medical doctor, for example. All right, how many officers and directors of a corporation at HR and board of supervisors are trying to tell you to stick you with a needle, rape you, penetrate you with a needle, okay, with an unknown substance? Because that's what's happening. Rape and penetration is going on along with assault and battery. Penetration, rape, assault, battery. For a person that's posing as a medical doctor telling you that you're supposedly sick, which is defamation, by the way, and this is you can't walk around telling people what they are and what they aren't without actually having the legitimate understanding of what they are and what they aren't. And of course, we all know the PCR tests don't isolate the virus. So there is no legitimacy to this whatsoever. So we've got people walking around acting the part and doing a medical simulation process. And even if they are a doctor and you're a nurse and you don't want to take the jab, according to the AMA ethics, code of ethics, the doctor is only allowed to give a recommendation. It is up to the patient whether or not they will take that recommendation. Okay, so I'm going to go back to the Quo Warranto because I thought that part was really exciting for people to hear. I mean, there's a lot of ways in which you can deal with them in this type of situation. So moving on, in some Quo Warranto proceedings, the issue is whether the defendant is entitled to hold the office he claims or to exercise the authority he presumes to have from the government. In addition, proceedings have challenged the right to the position of the county commissioner, the treasurer, the school board member, district attorney, judge, or tax commissioner. In certain jurisdictions, Quo Warranto is a proper proceeding to challenge individuals who are acting as officers and directors of business corporations. Now, what I have personally put together is not an information in the nature of a Quo Warranto. I have personally put together a writ of a Quo Warranto. Why? Because I am the queen of my own domain. No one has first claim over my genetic material. Only I do. I am the buck stops with me. It ends with me. So we correct, not all the way, but no one's going to rebut the affidavits. We have an 18-page affidavit, and I understand I haven't seen Ron's declaration yet, and I'm looking forward to reading it. But before I knew Ron, I put together an 18-page affidavit dealing with all of the tendrils that came out of this statutory system that were trying to enslave us. And so we're basically stating, claiming, yes, I am the man or the living woman, living, breathing, soulful woman standing on the land. And as the queen of my domain, I can issue a writ if you're trying to tell me what to do with my own personal being, my own property, my own genetic material that I'm responsible for. That's why I use writ rather than information in the nature of. I'm not going to fall into their category because we place ourselves back on the land. So the structure now, before I go on, maybe I should stop there and see if anybody has any questions. Or if maybe Ron would like to comment.
Not right now.
Okay, no questions? Okay. So essentially what a quo warranto is a conditional acceptance. Okay, and you can use it in many different ways. Conditional acceptance, there's two ways to dishonor the court. And we're going to go into a court situation right now. One is to stay in silence. So silence is acquiescence. And the other one, believe it or not, is to argue. If you argue, you're in dishonor. If you are in honor with the court, one way is just to pay the fee and say, yep, I admit to, I move on. The other way is to place a conditional acceptance in front of them. Ask them a quo warranto. Do they have the authority to do what and say what they're doing? Now, how you work this type of instrument is that you put it together in a sense that you're going to have your affidavits along with your writ of quo warranto, which states in there, look, I will bend the knee to you. I will pay the fine. I will take the jab. I will go to jail. I will do whatever it is that you want me to do. If you can provide me proof of claim, which is in an affidavit of validation, you need to provide me a proof of claim where it states that you have first claim over my physical body, as an example. Can you provide that to me? If you can provide that to me, then I will bend a knee to you. Now, in the clients that I work with, I have 195 proof of claims regarding this specific issue. So we not only go into the law, we not only go into case law, we not only go into proving whether or not we are the woman, man standing on the land, proving not whether or not we go into the fact that you've got to prove that, that you can claim me as your subject or as your property. You've got to show contracts and so on. So we start with the heavy stuff first. And then, not that it's necessary, but just in, we all, then we go and filter down to the other things, such as what are in these, first of all, so-called vaccines. It's not a vaccine. It's an experimental gene therapy, right? I'm sure you guys probably know that, but the dark forces out there have already gone online to Webster's dictionary, and they've changed the definition of vaccination from antibodies being placed into your body to actually mRNA and spike protein and all these other things that, don't belong. So that's already changed online. I have a dictionary from Webster's from 1991 that I just took a copy of, and I placed it in the writ of quo warranto. And I said, look, we're going off of this definition. Not that they have the right to do that anyways. Let's put it to you this way. and I'm sure I'm preaching to the choir here. If you wanted to take metal and blend it up in your blender and drink it, that's your prerogative. I wouldn't recommend it, but that's your prerogative. No one can tell you what to put in your body, even if it's an organic salad and the best organic salad you could ever have. No one has that authority, right? Only you have that authority to be able to say what you want to do with your body. So whatever, thing that propaganda that they want to sell us on, at the end of the day, we have to know that if they try and put the best lunch in front of us, that's none of their business. That is not their domain. They're overreaching at that point. If they want us to do yoga for an hour and a half, that's none of their business. It's our domain, right? So it could be the best thing in the world, and at the same time, it could be the worst thing in the world, which is what we're experiencing right now. But, if creation has given us free will, then those that are exercising this authority are overstepping even what creation will overstep on. And that's sort of the introduction of basically opening up this writ of Quo Warranto, is stating, look, there are rules to this game in this realm. And the creation doesn't even pretend to stop us from making our own choices. Who do you think you are from doing that, for doing that? So we basically state, we'll bend the knee if you can prove up to us, showing us that you have a proof of claim, line by line, word by word, for every 195 proof of claims that I have in here. I'm going to have to ask you for a proof of claim. If you can do that, perfect. Now, if you can't, this is my deal that I get to make with you. Here's my alloidial fee schedule. And in this fee schedule, you continue to harass me, I'm going to charge you $350,000 per hour per employee that harasses me, or employer, pardon me, employer. Third party agent and attorney, that's $550,000 per hour. I'm just throwing some numbers out there. You fire me because you want me to put this unknown substance in my body, that's $1 million. You're going to impersonate an attorney because you're telling me that's a law. Okay, you're simulating a lawful practice, that's $5 million. That's $5 million for putting yourself in that position. You're simulating a medical practice, that's $5 million. You're going to send CPS out to try and take my kids, that's $8 million. That's $10 million. I mean, you guys have got to put in there what it is that you see fit in your fee schedule, and you have to really let your mind go and think about all of the nasty, dirty things that they could possibly do to you, such as retaliation or leaving you in limbo. No one's going to tell you. I've got a client right now where no one's telling her if she's fired or not. They just refuse to talk to her. She's left in limbo. She can't even go and file for EDD. So she's stuck in a hard place. And there's a fee schedule for that. So we put the fee schedule together. Next, after the fee schedule, then you put your timelines. You've got 14 days to respond. You've got 30 days to respond. You've got 10 days to respond, whatever it might be. You get to choose the timeline. I personally would not, well, okay, with my package, our package is quite large because we not only put a letter of grace on top, but then in addition, we also put educational material. And that letter of grace on top is saying, look, perhaps you're not educated. I'm going to give you the benefit of the doubt that you are, just making some wrong decisions. And in making these wrong decisions, I'm going to give you a chance to correct yourself. So please correct yourself, review my affidavits, review the affidavit of validation, this Quo Warranto, and you have 14 days, or you have 10 days to respond, or you have 20 days to respond, because that gives you enough time to read the material. and then I layer it full of material regarding the Supreme Court case that states that those that have subjected themselves to taking mRNA are patentable products. That's a Supreme Court case, or a Supreme Court opinion, pardon me, Supreme Court opinion back in 2013. There's also another Supreme Court case in there that states that the CDC has lost a case to the Alabama Realtors Association because the CDC overstepped and placed a moratorium on those renters for about 8 months. And the landlords got extremely upset about it, went to court, and they won. Well, here it's this, you can see where this is very much on our side, placing this court case in there and saying, look, if they don't have a right, if the CDC doesn't have a right to be able to come in and usurp and take over someone else's property under the state of so-called emergency with a 99.9% survival rate, I might add, if they don't have the right to do that and take over the physical, the material property of someone else's, what right do they have to take over your own physical body, your own living body, breathing body, right? So we add these layers here to the Quo Warranto to see if they will come correct. We not only do this for the people that we're trying to educate, but we also do this for any admin or judge that's going to be reviewing the material to say that we've been as fair as possible. We've tried to give them every chance to come correct. There's more material in there as well that we've added in there, which is the FDA recalling the PCR tests because, as we all know, it doesn't isolate the virus. There's also Slovakian test from the Slovakian Republic that states that on the actual swabs that there is DARPA gel and lithium and all these other bad things that contaminate and will contaminate the blood-brain barrier. And there's an additional test that parents took the masks off children after the children wearing it for 2 hours and sent it to a lab, and they tested for like 14 different diseases, including meningitis. So there's we stack as much as possible along with the VAERS report. That's in there as well. So we place all this together with a Quo Warranto and we say, if you can't provide a proof of claim, and we've done our job to educate you. I mean, we really go out of our way to educate them. You can't provide the proof of claim and you're not going to respond back to us. Just so you know, this silence is acquiescence. And this contract is binding. And this is the way you properly respond in the contract. And so we'll offer you immunity if you give us our job back and we're able to work without wearing a mask, without showing you a vaccination card, show me your papers, a violation of 4th Amendment, without being plunged and raped and penetrated with a needle of unknown substance. We will put all of this aside if you will come correct. And of course, nobody does. So we let them know a remedy and relief is these 4 or 5 different options. And the client can choose which option they want. They can go to they can do a true bill, which is what we issue. They can choose arbitration if they want. I don't try to limit anybody when I put this together. I try to give them as many options as possible. They can go so the Article 3 court, Article 1 court, they can choose whatever options they want, including the fact that if there are unknown options that I'm unavailable or that they don't know about, that they can choose options in the future that are unknown at this moment. At the end of the contract, we basically write and state that we have the ability, if there's something that we've done that's incorrect in this contract, that just to notify us, and that we will come forward and correct any incorrections, and we have the ability to be able to go back and amend this contract anytime that we want. You always want to make sure that you can amend it, and we layer it with Bible verses as well, because as you all know, the Constitution is based on the Bible. So we put that Quo Warranto together and put it in front of them, and we wait for, and of course they send it off to legal, or they throw it in the trash, who knows. But then the next step that we do is we send over a true bill. And the true bill, we give them a second chance. And the second chance is the first cover letter that states, this is one more chance for you to come correct. This is second chance for you to rethink about your moral duties, your moral compass. We understand that this bill might put you in distress. This may unsettle you. This is not our intention to do this. So we're going to give you one more chance to come correct. And then stapled to that is a true bill. And in that true bill, it's an accounting of all the offenses that have happened to those that have not answered the writ of Quo Warranto. And that's a listing of everything that happened in the alloidal fee schedule. So in some cases, some of the clients have gotten harassed by memorandums or emails or phone calls, or they've had a third-party agent, such as the union, that's supposed to be representing them, or a third-party agent such as the attorneys that are hired by the corporations that are badgering them to take the jab. All of that has a consequence and a fee. And then at the end of our accounting, we have compensatory damages and also punitive damages that we add in there as well. Because you put these people through mental anguish, you've put them through a loss of life, a loss of liberty, they've lost a loss of wages. All of these things count. And a lot of these people have to do, I mean, when I work with them, they have to do their own research because I can't do it all. I'm not built for that just yet. I've set up the proper paperwork, but in some cases I'm like, look, this is your contract. This is your union. You know, this is your MOU. You've got to go find these things, and you've got to read through them, and you've got to look through them. And that's the biggest mistake so many people make, is that they get themselves involved in something years ago, unbeknownst to them. They just sign it because they're just wanting to take the job, and they have no idea what they've signed, and they don't know if they're in contract with these people or not. So, you know, that's one of the things that's in the alloidal fee schedule is your company, is your employer in breach of contract, right? Are they engaging in the defenses of a contract? That's another thing to think about. Mel, you have a question?
Yeah, just a comment. Thanks. I wanted to reiterate what you just said about really owning your paperwork, because as much as you know, as amazing as your paperwork is, I mean, I've seen quite a bit of it at this point. You know, it's great, and you know, this is I'm working on this for my husband, who had a mask issue with going into stores and getting, you know, put it behind in handcuffs and whatnot. So little bit different of a reason why we're submitting this paperwork, but yeah, I mean, you really do have to, you know, even if you get like a template per se, you know, really make sure that you understand what it is that you have in there. And if not, you know, it might need to be taken out, or it might need some clarification. So that was all. Thank you.
Yeah, absolutely. Absolutely. I can stop sharing now. This is hilarious. Thanks for commenting, Mel. So essentially, once they don't get the, so in the true bill, not only do we put an accounting in there, but we realize that the admins of the judge are not going to want to look through a 60-page contract. They're not interested in that. and that's likely to get things put to the side. So in the actual true bill, I've highlighted exhibits. Okay, so we take a copy of the first page that says the writ of quo warranto, and then we take a copy of the definition of what a quo warranto is. Okay, and we place it as exhibit A on the back of the true bill. So you have exhibit A, quo warranto, definition of a quo warranto. Then exhibit B is the fee schedule. Okay, so I have them make a copy of in the fee schedule, how many times or what were the offenses that were committed. And we place that as exhibit B on the back, but it's placed, let me just kind of show you here. So I just realized that probably how I'm saying this is not, it's better to get a visual. Okay. Shoot, sorry. Okay. So I have my maxims of law in the beginning. We have it to who it's actually addressed to. Labeled as the person that's being hurt is the libelant, the person that's doing the hurting, the injury is the libelee. We basically pull out the Fifth Amendment, which basically they're administrating property without right. So there's never been a contract to sign with two wet ink signatures that says that, you know, the undersigned or the libelant is the property of the employers or the board of directors or any corporation. Public health officials, public trustees, or the service corporation called the United States. Next, we basically say non-disclosure of a contractual offer. The libelant was forced to contractually offer, or either choose to be physically penetrated, raped, assault, battered, damaged. Breach of contract. In some cases, this doesn't apply to some people. They're not in breach of contract. They're month to month. In other cases, okay, so the number 4 is, are they practicing medicine without a license? Number 5, are they practicing law without being certified? Now, we all know when we're doing law and you're a lawyer and you're not an attorney, right? We all know that we can do this, okay? So I'm not trying to pretend and sit here and say that you need to be licensed to be an attorney. What I'm doing is turning around and using the language they use with us back on them. These are the corporate dead fictions that we're dealing with right now. And so we're using the language they try to use against us, which is, oh, are you simulating a lawful situation here? If that's the case, then where's your education? Show me, you know, show me how you know what the law is. They can't.
Comment on what you just said about licenses.
Yeah.
There are no licenses. A bar card is not a license. It's just a membership club because they've sworn an oath to the Queen. And that's what it is. And you have to recognize it as that rather than consider it a license, because they cannot show they have a license to practice law.
That's correct. Yes. Thank you for that clarification.
Yeah.
Absolutely. Next, we're putting in there that they're offering a contract to the libelant under gross negligence, fraud, misrepresentation, unconscionability, undue influence, malfeasance, duress, and violating public policy and law. Okay, so we capture as much as we can as we're opening up why it is that we're putting this true bill together. Here are the offenses that have happened. Okay. And then we write out the true bill as to when we sent the conditional acceptance, and then when we want the demand payment of the true bill. And then you have you see the attachments, okay? So the attachments, I placed the attachments on here, like I said, for the administrator / judge to look at, so that way they don't have to comb through a 60-page document. If they want to take the time to do that, that's great, but we're gonna make it easy for them. So I actually list the page number here, because some conditional acceptances are different than others for different people. So we list the page number here and the exhibits. And as I stated, you know, we're not going to let the judge get away with playing dumb and being ignorant. And they do this all the time. I just saw 3 weeks ago where a gentleman was trying to, in San Francisco, trying to defend the fact that he didn't want to take the jab and that, you know, they didn't have a right to administer his property without right. And he didn't know exactly the right things to say in court because you're under a lot of pressure and, you know, you weren't groomed or built for that. You know, you were doing something else your whole life. And rather than the judge coming back with law, he comes back with a New York Times article to finish up his statement and basically squashed everything this guy was trying to say. So, you know, that gives us real clarification on the fact that we need to point out to them exactly where the law is and that we understand what the definitions are. So we put in the fee schedule. We share with them an Exhibit C where the undersigned will conditionally accept the offer if you can show me that you can either rebut my affidavits or show me the proof of claims that I am requiring you to do. Okay, and so on. We have remedy. This is where we have remedy. This is where we have a timeline of when they need to respond. We define what a true bill is, just in case they want to play dumb. No, we know a true bill is a written instrument providing proof of obligation to pay money. Okay, so we're not letting the judge get away with anything. This is really more for the judge than it is for the person that we're sending it to. Okay. We let them know it's a binding contract and why it's a binding contract. We've offered immunity, an opportunity to exhaust your administrative remedy. Have they failed? Have they been silent? Yes. What will happen in the failure to respond? What about insufficiency of response? What is tacit agreement? Okay. And then we do Exhibit L, which is a copy of a memorandum of law and points and authorities on the Constitution ratified with the Bill of Rights in 1791, the corporate constitution, the California Constitution, the corporate constitution of California, the California Code, Title 18 codes. And as a matter of fact, we even place UCC in there for the judge's purpose only. This is not for really the person that you're sending this to. This is so the judge won't try to sit there and say, well, I don't know what to do with this. Oh, really? Well, in the UCC, it says this, this, and this. And so you've got to attend to these things. And then as we finish with our exhibit of notice of trespass, which we've placed in our package, which is, look, in a defenses of a contract, if you find you're in a contract, as an example, where there is a mistake or there's unconscionability or misrepresentation, you're allowed to break that contract. You're allowed to walk away and say, look, you know, there's error in this. There's a violation of public policy. I was influenced in a way because you have a power position and I feel like I'm in a weak position. I was under duress. Well, if you can break a contract, you certainly don't have to enter into a contract that's already starting off that way, right? So we set that aside. We also say the 6 elements of a contract. Was there a meeting of the minds? Was there a breach to the last contract? Where are the new terms and conditions? And give me your bona fide autographs, please. And the bona fide autograph means full disclosure. Has there been full disclosure? Absolutely not, because not even the Pfizer or Moderna or AstraZeneca want to disclose to the FDA, to the public, until 2075 of all the ingredients that are in this monstrosity of this Frankenshot. So there's no full disclosure. There's no meeting of the minds. Okay. And then we drill it down then to adjusted counting and true bill. So we put the true bill together. You know, how many offenses were there? I mean, normally it's just, this is just an example, but normally there's more than just one offense. There's usually 4 or 5 or 6 offenses. And then we calculated it all out. And we explain, just in case the judge wants to play dumb, what's compensatory damages. What's punitive damages? Just in case you don't know, we've got the definition right there for you, okay? And we even placed in there, this is actually in the Quo Warranto as well, latches will occur by failing to pay this true bill. Okay, so if it extends for a long period of time, it's just going to continue to accumulate interest upon this true bill. Okay, and then we sign it. So, and I have this, I have everything, everything on a sworn to jurat, all the documentation. And the reason why I have that is for a couple of reasons. The notary is an officer of the state. And a lot of times the administrator or the judge will ignore you. They'll ignore your paperwork because they can play that game, right? They can still pretend to see you as the dead corporate fiction. And if you're not the secured party holder, or sorry, secured party creditor and holder in due course, they can continue to still play that game. And sometimes even if you are the secured party creditor and holder in due course, I've seen it where they continue to still play that game. They still continue to like look the other way. That in of itself is a tort claim for sure. But we don't want them to ignore our paperwork. So there's a lot of people out there that will say, no, you just need 2 witnesses. And that in a fair world, that's true. You only do need 2 witnesses, but we don't live in a fair world. We live in a world of thieves and murderers and the people that are beyond the realm of greed that we could ever imagine. So we have to deal with it in a certain way. Now, one way to do this would be a notarial protest, where you could take a notary and you could say, look, they haven't responded to my defaults. And the notary will then send over documentation, say, hey, look, here's an affidavit, or sorry, a notice of non-response. Here's all the documents that were sent to you. You're not responding. And they do this 3 times until the 3rd time they give them a certificate, certificate of non-response, or a certificate of, gosh, it's not coming to me right now. Something to that effect. I have it written down, but a certificate of dishonor, that's what it is. Poof, came. Okay, certificate of dishonor. All right. So when we looked up in 2011, California, as per their communist and fascist ways, basically stated in their statutes that notaries are no longer allowed to do protests here. The only way that they're allowed to do a protest is if they represent a bank. So how do we get around that situation? You can't just do 2 witnesses and expect this admin, this administrator, or this so-called judge to be able to recognize them. So what you want to do is, in my humble opinion, and if I'm incorrect, I'm willing to definitely amend and change my ways, but we notarize every single document, because then at that point, they can't ignore an officer of the state. And that should get through. Now, I go back and forth sometimes. I question myself on this because I want to make sure that we really nail it and get it right. But I think the safest way to actually put this together is to make sure that every single thing's notarized on a jurat. And at the end of the day, you do an affidavit of non-response from your clients. So that way they can acknowledge, look, nothing has been responded to. And here's my jurat swearing to the truth that nothing's been responded to. And now we've perfected the claim. Ron does a much easier, simpler way of doing this. I studied and taught myself this way, but it seems to be a way that's also, it's working this way too. It's a little bit more lengthy in timeline, but it is, it's so far so good. Melanie, did you have a question?
Thank you. Yes. So to do an editorial protest, I know that would be way down the line, but does it have to be a certain type of notary?
It can be any notary. Any
Okay.
notary. If you look in, I combed through many different international notaries. I've combed through old notary books. They all have the right to do a protest. So, but California is so corrupt. Even if you wanted to take your birth certificate and record it on the land records here, they'll send you a form and say, we'll arrest you the next time that you bring your birth certificate over here. And of course, where's your badge? What do you think what do you mean you're going to arrest us? Now the Secretary of State is not wanting to Apple steal people's documents, so we're going to have to go outside of the state to do that. I personally worked with two gentlemen that you happen to know back in November of last year, where we took their complaints and took it to the DA and took it to the AG and took it to the county, and then also took it to the governor. Ignored. Everything's ignored. So it's challenging to be able to operate in the state right now, which is why also, and can be a conversation for another time, but why we're doing two things at once. We're not only doing these quo warrantos and conditional acceptances, but we're also doing grand juries as well.
Yes, and I might say we're operating in the state of lawlessness, and their situation is one of just being anal retentive.
Mm-hmm. Yeah.
Mel like that.
Actually, not to change the subject, but if you wouldn't mind, I do have a question about something you mentioned a few minutes ago. So you were using the terms rape, but do we have to actually say medical rape? I'm just curious if that's an actual term, or if rape actually does mean a sexual crime, or if it can actually really be.
Most people, when they view rape, they think of it as sexual, but rape is penetration. And so you can penetrate with a needle, you can penetrate with a stick. I mean, anything that penetrates you is literally raping your body.
Okay.
We just have to broaden our term of that. Yeah, I had to sort of go through that and think and digest that myself, but yeah, this is rape. Let's see. Okay, so that's the power of a quo warranto. I wanted to share that with you guys. Do you have any questions at this point? And I know that probably Ron has a lot of comments, but does anybody have any questions?
You did a real good job. There's not many questions.
Oh, wow.
Quo warrantos are, in fact, extremely powerful. It's one of the 7 extraordinary writs, and really one of the highest and the most powerful, if you know how to use it. So that's what Tamara is focused on, and I think that's very good. I haven't focused on it lately, but I've done them in the past.
Thank you. So since we're talking about the 7 most powerful writs, why don't you, Ron, are you able to share with us at this moment what are the other 6 powerful writs that we could review? I don't want to put you on the spot.
I don't remember off the top of my head. My short-term memory is not the greatest at my age.
That's okay. That's okay.
I have a long career. I've been at this since 1964.
No worries. No worries.
No worries.
I'm looking into a writ of mandamus or a mandamus. I'm not sure how you want to pronounce that, but yeah, I find that also very powerful, but that's getting pissed on right now by a lot of people still.
Yeah, if I was given some time, I could probably think of those. It's been a while. I've reviewed those lately.
No worries. No
I've
worries.
been staying out of the statutory arena for the most part for the last, at least 10 years or longer. Once I took down the Vatican the way I did in 2010, I let it go. Except
Mhm.
going to the district court in 2012, I did get a default judgment there. And we're collecting on that now, so all is good.
Are you, may I go into details on that right now, or is that something that needs to be left for another time?
On which?
When you're saying you're collecting on that now, I think a
Yeah.
lot of people kind of wonder about the collection process.
Yeah, well, my lien was recorded in 2007 back in Ohio. It was primarily based on the way Ohio treated me as an American, because I was already a private American national back in the 90s and knew it way before I knew who Anna was. I didn't discover her till 2008 and used a little bit of her information and appoints and authorities with what I did with the Vatican back in 2010. And you could see the results because they put a Jesuit in to be Pope when a Jesuit cannot be Pope. It's against Roman law. So there you go. So but Benedict is still running the church and the Vatican as far as that goes, but he's running it from a secret enclave. That's the way he works it, because there were so many arrest warrants out against him for pedophilia. It wasn't funny. And that's where they stand. And which I don't want to get into too much, but that's one of the problems we're having with the other half of, I won't say it. The assembly. There's some Jesuit oaths and things in there too. So we got to watch for that. I'm on the guard for that all the time. I know all about the Vatican and what they've done.
Well, if you look at the Jesuits' fourth vow, and how serious this is, and when you see this in a meme sense, right, it can appear like, someone made this up. This can't even be possible until you realize you pull it from the congressional record, and it's in the congressional record. You go, oh my God, this is real.
It's heavy. It's heavy. And it's not pleasant.
Yeah.
You know, Jesuits are not exactly what you call Christians.
No.
The opposite.
Yep. But so you were telling us about the collection process.
Okay, well, what I'm doing, because this was in Ohio and I didn't want to go back to Ohio. In fact, I'm kind of a marked man in Ohio. I wouldn't trust my life for more than 10 days there, if that long. Because I have a judgment on them to end all judgments. I think it's at 6.7 billion right now. And we have, you know, Ed from Georgia. Yeah,
yes,
he has somebody working on this for me who used to be one of my law students back in the 90s and knows me and says, oh, what, Kelly? Oh my God, yeah, I'll do Kelly's. He's really excited about doing it. So we've got a conference coming up here in the next day or two. We got to talk about things. There's apparently a couple ways they can get it done, and they're quite confident of succeeding. So I've kind of put it in their hands and let them do it, and we're working on it. So
that's wonderful. That's wonderful.
Yeah,
We're looking forward to the good news.
We'll have some internal financing if that comes through.
Yeah. Yeah. Well, you know, I mean, I think if you guys remember, like Ed did share, because I asked him the same question.
Yeah.
Remember, I thought after you take the default judgment and you go straight to the sheriff, and he was like, no, you need to go and do a writ of execution, go back to the clerk's office. And so there were some insights that he gave me that was very, very helpful. And, you know, one of the things that people try to play that they don't have any money, such as risk management, and risk management is the insurance company for the state. If they try to cry, oh, well, we want to lowball you and pay you $5 or whatever lowball amount that they want to pay you. It's like, oh, no, let's pull up the CAFR accounts.
Yeah.
This is something that I researched 8 years ago, knowing about the comprehensive annual financial reports. Yeah. It's like, no, let's just see a copy of that and see how much money you have.
Coming out of a CPA firm as I did, I was hired to be an audit manager and to be partner in the firm. $6 million a year they're going to pay me. But before I got to the $6 million a year while I was studying law, I discovered the fraud that they were in fact supporting, and called the head auditor on it, called him down right in my office. He had that old man feeling like that tall, and he just buried his head. He couldn't believe it when he finally, I showed him the trees through the forest, and once he discovered it himself and says, oh my God, that's fraud, then he realized. I said, well, what are you going to do? What are you going to do about it, Mr. Senior Auditor? 32 years with a firm in that position. You should be ashamed of yourself all this time you haven't known that. Well, I guess I gotta go up and talk to the partner. Well, that's a good start, but I don't think you're gonna get anywhere. And sure enough, the partner admitted, he told me, he says, yeah, he admitted the whole thing. Yeah, it's all fraud. It's all fraud.
Yeah.
Everything from the top down, and that includes the courts, because the courts are the bank.
Yep.
You haven't studied my mortgage flow chart, you need to study that carefully, because the courts are the ones that are creating all the money in this world by these infractions, misdemeanors, and felonies they're charging everybody with. And that's why they're so hell-bent on collecting. But all they have to do is get it in the process. There's 6 bonds they use. Standard Form 24, 25, 25A, 273, 274, 275. Each one is worth $30,000 now on a mere infraction. And there's 6 of them. So that's $180,000 for spitting on the sidewalk or running a stop sign or speeding. Okay, so you can see why they've got all these cops out there trying to write all these tickets. But a misdemeanor, when they get the misdemeanor charges, that's 10 times as much as $300,000 a piece, or $1.8 million for the 6 upon conviction. And they never charge one count. Same way with felonies. Felonies is 10 times again. So it's 3 million a bond, and there are 6 bonds. So that's 18 million a felony count. That's how I got my judgment back against Ohio for what they did, because they tried to indict me for what I knew, not for what I did. And I turned the whole thing around against them, even took their most senior judge down from the appellate court.
Wow. Ron, do you have that mortgage flow, or sorry, that, the mortgage flow chart that you were just talking about?
Yeah. I can make it available. I can post it somewhere.
Okay. Will you post it, please?
It's also on the California website.
Yeah, it's on the
it is?
California website. Yeah.
Is that California website, is that posted here?
Where is it, Jeannie?
And by the way, thanks, Kim on Orange. Appreciate that.
Yeah.
I believe Kim also has it on the California or Orange
Yeah.
County Assembly website too.
I mean, I can send it to you now if I know where
I
you
can
want
send
it.
it to you too.
You want me
Tamara,
to
I'm-
email it to you?
Perfect.
I
Okay.
can do that. Give
Yeah,
me an
it-
email address and I'll send it to you.
All right,
Kim
cool.
Kim just confirmed it's on the
Oh,
Orange
Kim-
County
Kim
Assembly
did?
website. Yeah.
Okay.
Awesome.
Also, I have a question for you, Tamara. How far are you, the process that you went over? Do you have any success stories yet? Or is it something kind of new that you did?
This is in the works right now. So we have a client that's very close. So we're probably looking like a month and a half out.
Gotcha.
It does
Yeah.
take time, no matter
Mhm.
which way you do it.
Yeah, I mean, the reason being is that there are like things that are happening that haven't happened before, such as, like I said, the Secretary of State not apostilling
Yeah.
information. So we're having to go different routes now, which is causing delays in what it is that we're doing.
Colorado should do it for you.
I will share this with that. Yes, exactly. Colorado run. I will share this with you. I've had friends who are in the same level of game that I'm in. And I consider myself a very minor player, but they've actually used the Quo Warranto on cannabis violations when they had to walk into court. And when they did that, of course, they were looking at like, these are people that are not gangsters, these people that are healers.
Yes.
So let me just clarify that, they are not people that, when I talk about cannabis, I talk about the healing plant, and I associate with those that understand that property. So these people were abused by the Sonoma County Permit Center. And the Sonoma County up here, they are literally going after every elder and every farmer on their land to rape and take their land. To give you an example, just to sort of paint a horrifying picture, there was a woman that works that owns a huge amount of property. Her land got burnt down by the fires that have been set on us on purpose to kick people out of their lands. And so she went and cleared her land, She's in her 60s along with her husband, and her husband had a stroke. They had him sign a release form with the county when he had a stroke. She told him not to. She said he's not, he doesn't have the mental capacity to be able to speak on our behalf. So they had him sign the document anyways. And then she was pitching a tent on her land to tend to her cows that had burns, and she was trying to help them. They came onto her land and said, you need a permit. Mind you, the land is paid out for, right? It's all paid out for. Okay, so she doesn't owe any debt on the land whatsoever.
She should have nailed them for trespassing when they came on the land.
She didn't know that.
Tell her she needed a permit.
Yep. She didn't know that at the time, but we put that together for her, and they eventually did leave her alone. But they were trying to tell her, we're going to charge you for pitching a tent on your land because you are not allowed to pitch a tent on your land without a permit. So what they're doing up here.
And over-tented.
Yeah. They have an agenda, agenda 21, and
It's
agenda
all about the
21.
money.
Yeah. And this is a land grab, really.
Yeah.
Look at what Bill Gates is doing. He's now the largest property owner in the Midwest.
Well,
you look at.
They took care of him on the 6th. They hung him and his neck didn't break, so he suffocated. Took him over 10 minutes to die. Bill Gates is
Okay. Okay.
All right. Okay. Well, we'll see. Because there's a lot of disinformation out there, but I could be wrong. And there's also Blackstone and Vanguard who are coming in and eating up all the properties as well. So what we're seeing is the greatest wealth transfer and also the greatest property land grab ever known to history through this criminal act of the safety of your health and welfare for society.
Yeah.
So that's what.
Here's a $4 bill.
Right. Exactly. So going back to going back to the conditional acceptance with the guy with cannabis, he had hired an attorney, and his attorney was basically, rolling over on him, and he was looking at doing 5 years in prison.
They're called attorn-on-me's for that reason.
That's right.
Attorn-on-me's.
That's right. And he was taking courses through like one of our groups. And his mentor said, look, you need to put a conditional acceptance in front of them and just lay it out. Push the attorney aside, say, forget it, I don't need you anymore, and put this in front of them. He put it in front of them. They literally lost their mind. They pushed him out of the courtroom, said, get out of here, we don't want to see you, locked the doors on him, and dropped the case entirely. And this has happened to a number of different people in the circles that we work with, that we know have been able to handle the courts when you could go into a courtroom. Now it's a little more difficult when you go on. This is why you need to face your accuser, right? You need to be able to do a face-to-face because, of course, in the digital age, they're going to want to mute your voice, which is now what's happening to a lot of these clients. They're not able to express what they say. They just mute you and, oh, well, you know what? He chose to stay silent. How convenient.
Yeah.
That's why Ron's process is so brilliant. I just want to tip my hat to him time and time again, because it doesn't put someone under pressure to walk in front of a judge, number one. And number two, if you know what you're doing and you do it correctly, you will be able to see success afterwards, because I'd like to see risk management be able to try and say, we might encounter that, at the end of the day, it's so corrupt, we might encounter that, but then there's a claim against them.
It doesn't mean risk management can't take a claim.
That's right. That's right.
So that's what you have to do. After all these years, I discovered the DMV fraud back in '64 when I was only 20 years old. But after all these years, I got another big claim over the DMV right now, over their whole scam. It's all fraud, everything. State of California doesn't even own the DMV. None of the states do. It's owned by the Railroad Commission. I learned that back in 1960, maybe 60 something, maybe 50s, late 50s, no, 60s. sometime in the early 60s, I guess.
That
Ron?
totally makes sense. Go ahead. Sorry, Jeannie.
Sorry. Ron, can I ask you, when you say you made a claim on the DMV just recently,
Yeah,
what is it that you did?
I did my declaration. What else? Right here. It's massive. It's massive.
Is that
You see the
so,
things?
I mean, you're
It's-
doing
It's
all of
about,
the DMV
what
of
is this, about
California?
70 some pages plus exhibits? It's probably about almost 100 pages. But it covers everything, because we cover everything starting with the Vatican fraud and how they created the corporations and the corporate fraud, and the corporations create the banks and the bank fraud, and the fact that, you know, the courts are involved. So you got the court fraud, which is really doing the banking these days. But then it gets into the DMV fraud as well, because I got fed up with the whole idea about, I learned the whole thing about the pink slip way back in 64 when I got my very first one. I don't know if you can see it, but that's my very first pink slip from 1964. The first car I paid off. I was 20 years old. And I have another pink slip now. This is the current one for the current car, but they claim they own it. Of course, they never give you an MSO. You have to go to Oregon or Nevada or some other foreign state and get that. Tell them you live in California, you need the MSO to bring it back to register it. And then you don't register it. You simply put a bill of sale on it and hang the bill of sale in the front window, front passenger side. And we never got stopped. We drove our car for 12 years. We did that back in 1988. May of 88, we did that with a new Ford Probe when it first came out. Drove it clear into, I think, 2001 or 2. Put about 600,000 miles on it.
I guess what I'm curious.
Drove the
because
wheels off it. Never
I'm
registered.
not with the, so did you sent the DMV, the Department of Motor Vehicles in Sacramento,
Yes.
a cease
Yes.
and desist or
No, this is a declaration.
a fraud? Just,
This is the declaration of all their fraud. Ties all of it together, ties them with the Vatican and ties them with all the crooks. Everybody's tied together in this in one nice little package. And I added a section just for the DMV, okay, to address their direct issues of fraud. The fact that they cheat you out of the title, they insist on you signing a power of attorney over to them before you even deliver the car. So they're not, the dealer is not, because he's licensed by the DMV, is never giving you a legitimate title. You register it. Registering means giving it to the Queen. It's Queen's property, Queen or King.
so I assume you gave them 30 days.
Oh, they get 30 days. Yeah.
That's typical your
You know,
time
about
frame.
20 days, they'll get a notice of fault because we won't get a response. I sent it to the director. We did one for George just a couple months ago. Remember George Lutano? Yeah,
Yeah.
we did one for them also on his case because they stole one of his cars and threatening the other one. And he had to have it registered, have it smogged and all that stuff just to be able to drive it a little bit around here. I was afraid they're going to steal it too. So we put a stop to that, but I haven't heard. He's so busy right now with the resets that he's hardly.
You called today.
But he did call today, so.
So are you saying that we won't have to pay DMV registration charges anymore?
Well, when I get done with this, we're not going to have to. You can ride piggyback. All you gotta do is cite this one and say, well, due to your admission in this case, you want the case number? Although it's not done yet, so I wouldn't do it yet. But the case number is RE 1111121 11/11/21. That's when I launched it.
So when you say piggyback, I'm sorry, not to go off what Tamara was saying. I'm just intrigued by the DMV.
Well, I don't think everybody has to do a declaration. Once the facts are evidence and once they've proved, you can use that case just like you would a case in their system that you cite. Cite the record is the fact that they defaulted on this case. And therefore you wouldn't have to do it again. You could if you wanted to, if you want to go for damages. Otherwise, you just want to hold them off. You just cite the case.
Then we wouldn't have our tags on our plates.
No, you have to do your own licenses. We're working on that. too.
License. Okay,
Yeah.
good.
We have some real good stuff come up. There's a
Well, that's a whole
US
nother topic.
there's a U.S. Department of Transportation tag available. You just call up there and get a number, and then you get one of these other places that will make these things for you, make you up a plate with that number on it. The numbers have to be 3 inches tall, and that's it. 6 or 7 numbers.
Sapa's
Much less
asking, so the MSO is hard to obtain then?
Well, the MSO, if you're buying a new car, you can go in like you go to, what I do, I suggest going to Oregon because there's no sales tax up there. So you're going to save thousands on the sales tax, but you have to buy a car outright. Just go up there and buy it if you got the money. You just ask for the MSO. Say, well, I live in California, so I'm not going to sign your power of attorney or DMV because we're not going to register it here. I've got to register it in California. I need the MSO or the MCO. Sometimes I call them MCOs. And they'll give it to you. So will Arizona, so will Nevada, but they charge sales tax there.
How would we get the MSO if we've already bought a car in California? Or is
You
that a whole
don't.
nother topic?
First thing the DMV does with them when they get them from the dealer is they destroy them, they burn them or whatever they do. They record them and then they burn them. So they can't be given out. You're not going to get a MSO on a used car. The best thing you can do is a bill of sale, because the bill of sale is the legal title. Oh, I had cops stop me when we drove around for those 12 years, 14 years. We drove that Ford Probe. We were stopped a number of times. We just show them the bill of sale. Here it is. You know, it's our car. It's a title. They knew it. I go the other way. Now, my wife made the mistake one time of putting the Kelly plates on it because my ex, because my parents moved out of state, they retired. And they gave her the plates, and she wanted to put them on the car, so she had them put on the car. And sure enough, we're driving back from San Diego one time, got stopped. And we were there at the side of the road for probably 45 minutes. They had to call a tow truck to come out to get with a special wrench to get the plates off the car. And once they got them off the car, they kept the plates. I says, well, that's the end of that. So we don't need plates. We put dealer cold plates back on it again. That's the cardboard ones that comes with it when they're brand new. The dealer advertising plates. But you got to keep your car looking nice to do that. You know, we always kept ours looking new, so therefore they didn't draw attention. It looked fairly new. And then see the paper plates on the back, and they'd see the little stick, little folded up bill of sale in the windshield. They just drive right by us. And I think they still pretty much would. But you keep an extra copy of that bill of sale in the glove compartment. So if they ask, you can pull it out and say, yeah, here it is right here. Take it off the window. Here's the one right here. No, that's up to tape.
Wow.
We did that for 13, 14 years.
Wow.
That was then. This is now. Yeah, things have changed a little, but the same idea. So anyway, we're going to see.
The
what
fraud
DMV
never
says.
ends.
What's that?
The fraud never ends.
Oh, the fraud never ends. Yeah, it's just getting worse. It's really gotten bad since I've been back. I thought it was bad in 2000.
I have a quick question on the MSO really quickly. When you go and actually pull a new car off the lot, my understanding was, and maybe you said this and I just missed it, is that you have to pay for the car outright. They won't give you the MSO if you get a loan.
Well, typically you're not going to get financing, particularly if you go to another state where they'll give it to you. It's very unlikely you're going to get a car dealer in California to give you the MSO. Perhaps if we could work up some paperwork to convince the car dealer and put them under declaration, give them time to rebut it or own it. And if they own it, then they got to release it. Because they are committing fraud. It's just out and out fraud. They're in bed with the DMV. The DMV, they're licensed to the DMV, and therefore they have to follow DMV rules. Now, what ticked me off about the dealer we bought our car at is they wouldn't let us reserve our rights. We did on all the contracts. Got down to that last page. It was for the DMV on the registration. We can't do that. The DMV will never take it that way. Well, that's too bad. You're going to deny me my rights? To reserve my rights, you're in trouble. And I have a $5.6 million lien against the car dealer right here in Orange County. That was already perfected way back in June, I guess. June or by the 1st of July. I think we bought the car in May. But we got to collect. I don't know a lot about collection myself. So
Wow.
we're going to learn something from Ed and his voice.
I think Tony has her hand up. Tony?
Tony?
There's one
Yes,
slight
Oh.
problem.
You guys are sitting next to each other.
This Tony? That Tony?
So there's an echo.
I'm sitting here for a reason.
Oh, she's sitting here for a reason. Yeah. Yeah, Tony.
There's one slight problem. I'm driving the car with expired plates. So until this works, what happens if I get pulled over?
We have them under estoppel right now. They're under estoppel the minute they receive this.
But will the policeman know that?
Policemen won't know that. We need to keep a copy of the paperwork in the car. I have to make one. Not that we can carry in the car.
I yield.
Yeah. Well, whoever said it'd be easy, whoever said it'd be easy.
I better drive very nicely.
So much. I mean, by trying to keep me from reserving my rights, above my signature. So I just scribbled on there.
Yeah, I told him to scribble.
It wasn't my signature. That was all rights reserved without prejudice. You can't see that here. That's what I wrote there. I was a little shook up after you wouldn't do it. So
Wait,
Okay, time out, time out.
Time
Yeah,
out.
there's way too much feedback. Hold
Yeah.
on.
You guys have to mute one of your computers when you're talking.
I muted
Otherwise,
mine. I muted
Oh.
mine.
okay,
Yeah,
a little better.
I muted.
Oh, me.
Yeah.
okay. Oh, Mike Mickey has his hand up. Hold on. Wow.
Hey, Ron, how are you, buddy?
Now he's got to
Oh,
unmute.
he's muted.
Now, Ron, you have to
Yeah, he's-
unmute.
Regarding the MSO, David Straight talks about buying it from a
Steve,
dealership
Okay, sorry.
and that, yeah, David Straight talks about buying a new vehicle from the dealership and just telling them that you're going to export it out of the United States.
That's one way you can do it. Mhm.
Yeah, and then you basically get a tow truck that takes the car off the dealership onto the surface streets, and now you're in the United States of America.
Yeah.
So technically, you did export it, and you should
You
be
export it
getting
to the United States.
right.
You're
Exactly.
not on their corporate property anymore.
Correct, Mundo.
Yeah, yeah, I've heard that story too. I haven't tried that yet, but I think it would work.
Wow.
There's no reason why not.
Interesting. I know we got a little off topic, but that was,
Yeah.
when he
well,
mentioned he served, you don't.
Everybody
every
has to
day
deal
that
with cars.
He
We
confronted
deal
the
with cars, we
DMV.
deal with all kinds of issues, right, Mike? Mike could tell you.
Absolutely.
Yeah, but we're dealing with dishonor too, and that's the thing about those notes we're doing. I put a hold on that for the time being because we're getting too much dishonor in the courts, and we have to get the people to learn enough to go after them for the dishonor because they're not allowed to dishonor those. They're issued under Public Law 7310, which is our remedy, belongs to the people for the theft of our gold back in 1933 by FDR and his crew. And it's also issued under pursuant to the Trading with the Enemies Act, sections or Appendix 5 and 7, which once you mention that in open court, watch how fast they run. That is very damning to them. And then UCC 3-603 says if they dishonor it, they have the personal liability to pay it. So we pin the liability back on them. We notify the payee that they have to go to the clerk of court, which is the bank, and get them to pay that instrument. And that's as far as our liability goes. The rest of that is on them. But we can get damages in the meantime too.
That's great.
So
Thank
I've been
you.
doing that
Ron.
since the early 90s. Been doing those discharges. In the 2000s, I learned how to do it directly through the trustee and was getting them paid by wire transfer on the morning of the 21st day every time we issued one. And it doesn't matter the amount, $1.5 million, whatever it was. It just, it just clear on the 21st day, the money would show up in the bank. So we'll get that restarted again as soon as we can get people working out a plan to go after them for the dishonor they're doing, because that's got to be dealt with. And really, you can use my process for doing that. You got to use a big declaration, pin them down on that for their dishonor. They're so involved in fraud, how they're going to get around it? They're going to have to admit it or acquiesce to it. It's their only choice. So that's why I developed this system years ago, really way back in the 90s.
Ron, we have another question, a
Yeah,
hand
go ahead.
raised. Mel?
Yeah, Mel?
San Diego?
Hi, everyone. So at this point, we've done some wonderful in-depth affidavits from Tamara, and then we did Ron's 60-page notice of corporate fraud and declaration of status and notice of corporate fraud. And so I'm trying to figure out the bill. So number one question is, do we send the bill directly to the clerk of court or to the district attorney who is the one pressing charges?
No, you always serve these. You don't take it, you serve it on the clerk of court for your county. That is the fiduciary over your city KY trust. Anna reported about that, well, early last summer, I think. There's a couple different articles on it. And I agree, it is the clerk of court. We've tried them through the judge. The judge will always use the excuse that he has judicial canons and he can't be a trustee of anything and so on. But he does act as a trustee as well. But
Ron,
you
I
can't
believe she's,
nail him.
Ronnie, I believe she's talking about a civil matter, not a discharge matter.
Yes.
It's a criminal trespassing case.
A criminal
Yeah, yeah.
trespassing case. Okay.
Yeah.
It's not a discharge.
That's what I was going to ask, is that should she not send the true bill to the person that's actually trying to charge you for the trespass? And then when he defaults, that's when you go and get it verified with the clerk of court that she's using all the notaries and then take it through that process.
Right.
Okay.
Yeah. Any of that monkey business they throw at you, you can use a declaration to address the fraud that's going on inside the court. The fact that the court is running the bank and the court is generating all the money for these banks and other lenders, including Sally Mae, or, your student loans as well as everything else. That is enough to convict them of that. They're going to admit it. They don't have any way around it by the way it's written. So they're going to admit to these things, and you pin them down. You work with a default. You issue a true bill on that, and that's your damages. So it basically works. Question?
And then, so since I have sent a conditional acceptance, my bill shouldn't then reflect only what was on the conditional acceptance. I know I'm kind of like combining, two brilliant minds right here with Tamara and Ron. But I'm just wondering if that's, is that a valid statement, or because so with Ron's 60-page declaration, there's nothing in there that says any kind of fee schedule or conditional acceptance.
The fee
But then
schedule is not in there. We use Anna's fee schedule, but you can use any fee schedule you want out of Title 18 USC because that's the law that they are liable for. And you use the penalties that are in there. Those penalties belong to us, not the courts. God knows how much money they're making on this.
Right. So I was trying to put in there the, cite the laws and whatnot for each charge that we have on there for your bill, Ron.
Yeah.
And I could do that with all of them. And I remember you said put them in brackets, which is the 4-corner rule, which basically it's in the contract, but it's actually not a contract. It's just there for reference, but it's not actually part of the
No,
contract.
If you're using sites, you use the 4-corner rule.
Okay,
You
so I
change
could do
their
that.
sites. Yeah, so you're not citing the law.
Thank you. So I could do that with all of them, except for the very last one you have on there, which is default and dishonor. So I wondered if you might be able to, explain that to me a little more, or possibly
Well,
even cite.
Okay, the administrative process is a 3-step process. It's notice, grace, and the final judgment. Okay, and it works like this. When you notice them, they've got 30 days. They're in estoppel during this time. You give them a notice of estoppel, so they can't proceed against you. It stops all actions against you. If it doesn't, that's called a criminal trespass, and that increases your damages by a 3 times penalty. So that means you're going to get 4 times as much when it's all added up. But if you haven't got there yet, when you get to about 20 days, you give them a notice of fault, which is the grace notice. It tells them, yeah, you have until the 30th or the 31st day, whatever it is, You work it out on your calendar, and that counts. The day of service doesn't count. It counts from the day after service. So you're giving them a little grace in the front end, and you're giving them notice of grace on the back end that they have 10 days or whatever it might be to get their responses in with evidence and support. And you get to be the judge. If it is not sufficient evidence, you can write it up as such and say the judgment's found against you because you, even though you tried to rebut this, your rebuttal doesn't hold water, and you did not provide any evidence of that being the case. Tell you the truth, I've never had a rebuttal. Not to one of mine.
Right.
They can't. They really can't. It's just written in such a way they can't. There's too much truth in there. They have to really try and tear down the truth, and that'd be pretty hard to do. It's all a matter of historical record and a lot of their own files, their own admissions. So when you get to the true bill, that's when you get the final judgment on the 30th day, really on the 31st day you do this. You issue the final judgment in dishonor, in default in dishonor, and then you issue a true bill in commerce. The true bill is like an invoice. You're going to look at all the things in Title 18 that they have violated. And let's say some of the fines in there might be $50,000. Some might be kidnapping, $6 million. So if they took you out of your car or something like that, took you to their car, like a couple of people I know, when they do just a traffic stop, that's a kidnap. They can't move you that far. They're not supposed to do that. It's against the rules, even against their own rules. So anyway, some of those are quite large in there. Kidnap's one of the larger ones, but those do add up. And when you look at it and you say, well, actually this one they did 3 times. 3 times they did this. Now, if they trespass on you 2 or 3 times, what's going to happen? Each trespass, criminal trespass, once they've been put on notice like this, is a 3 times damage. That's the penalty. So you got 3 times, and then you add 3 times on that again, and 3 times on that again for the 3rd time. How much you got now? 3 times 3 is what?
9.
9. And then 3 times 9 is what? 27. You're going to have 27 times more than the original damages, plus the original damages still. So it can get quite large that way when they mess around with you. They've got to learn to respect what you're doing and respect the actual law. And it's all very well cited in there. Everything's spelled out. You know, if they want to rebut it, they're free to do that. They want to rebut their own case law, they're free to do that. A lot of case law is cited there.
Right.
The least of which is not the Clearfield decision of 1943. That's one everybody should know. Y'all know the Clearfield decision? Anybody?
I don't.
Did you know?
Did you know that the Supreme Court ruled in 1943 that when a government entity descends to operating as a mere corporation for profits, that they no longer have any 0 sovereign powers? 0. So you see, they're all operating in fraud because they're all operating as private corporations for profit anyway now. So how dare they think they're a government? They're not. They're a service corporation, and we're their bosses. They don't want to recognize that. That'd rain on their parade, but nonetheless.
Well, it seems like the estoppel is working. You know, that was part of the 60-page declaration. They have kept his bench warrant active, but they have not rescheduled his new court date. But the same district attorney is now pressing charges, same criminal trespass charges against him for something that happened at a different store, where he was actually shoved out of the doorway into a little brick wall that has like plants on it. And
well, you can amend your declaration, go back and name that as well, you know.
okay.
And that was just for not wearing a mask.
Well, he has a YouTube channel called Maskless Ninja. So he would go into stores that would be especially tyrannical with the mask policy, and he would basically prove to them that yes, he can go shop in there without a mask. He would do it as quickly as possible, he wouldn't try to, really talk to any people. They would talk to him sometimes and follow him around and try to, get him to put a mask on. And of course he has a medical condition and he can't, there's just no way. And so he would try to pay at the register, and then they said, okay, well, we're not going to take your money next time. And he said, well, then I'll just leave my cash at the register and walk out with my stuff. You can't discriminate. And he did that at Sprouts many times. And then it became like almost like a game, like how many times can I go in there and get one thing, Anyway, so then he did it at Costco. He did it at a couple other places, but this one local health food store in Temecula, which is in Riverside County, it's called Organic Roots. One of my friends was working with the store manager through the Peggy Hall way, the healthyamerican.org. And the manager was seeing the light, and they took the sign down and said, okay, yeah, you customers actually can shop in here without a mask. It's not recommended, blah, 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 but they can. So the next day, one of my minor offspring properties were sick. And so I sent my man to this store, which was the only other store in the area that even sells this product. It's called BioK. It's a little yogurt cup probiotic drink, but it just works miracles. And at the time, it's changed now, but we weren't even able to go on their website and order it personal home delivery. They would just direct you to the nearest store. So can't go to Sprouts anymore. So the last place is Organic Roots. And the last time he went there was the day after they lifted the mask mandate for their store. And but the employees that were there at the time recognized him and said, oh, you can't be in here, which he was never officially trespassed by a law enforcement officer. It was just like the store didn't want him in there. So they just say, oh, we can refuse service. Well, actually, no, you can't. And we know why. We know all of that now. But at the time, they didn't know. And so one of the employees saw him standing in line. So she kind of like, as soon as the guy in front of him left the aisle of the register, she stepped in and was like, blah, 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 you're not coming in here. And it's all on video. And he's like, well, then here's my money and I'm out. So he just kind of like scooted around her and tried to leave. And this was the first time he actually turned around and addressed the shoppers and said, hey, you guys are supporting a tyrannical store or something like that. He turned to walk out the door. Yeah. He turned to walk out the door, and they stepped on the back of his shoe and shoved him kind of out and tried to grab his stuff and said that he didn't pay and they're holding the money. And it was, obviously he didn't expect that because they lifted the mask mandate, and I don't know. So there's a whole nother case we have to deal with now. So yay. But just now we know what to do. It's just the whole, we're at the point now where we're supposed to send the true bill. It's actually already 2 weeks late. So
Never too
I'm a
late
little
to serve the true bill.
serve, right? Always have to serve it.
Yeah. It's never
Okay.
too late to send it because you can give them as much grace as you want on the end of the time.
Yeah.
You don't have to
Yeah,
do it
that's-
exactly 30 days, but I recommend to most people they do it on that 31st day. Do it timely if you can, but we know there's other circumstances, things come up and so on. It
Yeah.
can't be done. So if it's
Awesome.
late, it's late. It doesn't matter. You're just giving them more grace. That's part of the principle.
Yeah,
And this
that's
all
what we were
comes from the
doing.
scriptures, people. And it's all listed on page 4. Tells you all the scriptural sites that's used in here. And that's what this really is. It's a God-given process. That's why it works the way it does. And it will. Now you have to know what you're doing with it a little bit. You have to have enough smarts to know that you're doing the right thing because you're doing it according to scripture. And you're giving them grace, you're giving them notice, you're giving them grace. My God, look at the notice. 50, 60 pages. If they can't figure out by then that they're way over their heads in fraud, they're beyond hope. They're beyond redemption.
Right.
And many of them are, I believe. But business that's open to the public, or that's supposed to be open to the public, has to be open to the public. They can't discriminate.
Right. Well, thank you, everyone. I yield.
Ron, real quick, can you clarify, was it the clear field?
Oh, the Clearfield document? I mentioned that 1943, the
Yeah.
US Supreme Court ruled that when a government entity reduces itself to operate as a mere corporation for profits, they no longer have any sovereign powers whatsoever. They've waived their sovereign powers by
Thank you.
operating in commerce for profit. In other
Just
words, a
wanna-
corporation cannot be a government. And what we have today is corporate government, don't we? So it's kind of an oxymoron. Corporation can't be a government. You operate for profits. You cannot operate that way. You have no power whatsoever. None. And why have we been sitting around since 1943 waiting to get these guys? That was before I was born, but why has everybody been waiting so long? I don't take
Well,
the phone.
We're here now. We're here now. We're here
I was hell
now.
on wheels here in Orange County back in the 90s. You wouldn't believe what I was doing in court and getting away with it. I'd go in there, I'd slam judges, I'd arrest them, I'd arrest cops, I'd arrest prosecutors. You know, I knew the law and I knew how to bring it about, and how to bring it down. And I could just go in for a simple discharge, and somebody gives me some lip and goes the wrong way, they're in trouble. They don't know what they're dealing with. So they tried to get me in 1998 to join the bar. They actually brought me into chambers and showed me the bar association across the street out the guy's window. I said, yeah, I know what this is. I had a client next door. I had a lot of lawyers for clients on my computers. And he says, yeah, we're going to take you over there, pay you a lifetime membership and all this stuff. And well, if you think you need to, although you probably know more about the law than any of these other lawyers do, you've been winning all your cases. In fact, more than many of the judges. And I laughed at him and says, yeah, like your boss that I arrested 2 days before that. Because I did. I arrested him on a misdemeanor count for denying me due process of law. It's in the California Penal Code. It's a 5-digit one. It's somewhere near the end. It's hidden. But I found it. I had copies of it on me so I could show it to him. But he just got up and ran. He dropped his robes in the doorway and just ran through the back door of chambers. And he did go look up the law and found out I was right. He didn't know that one. Again, I knew more about the law because I had to study law. I didn't study procedures. I didn't go to law school. I went to a CPA firm and I had to read all the law books. So I probably read 100,000 law books in that time period. Who's ever read 100,000 books? Anybody?
Not
Try
yet.
100,000 law books.
I'm
Yeah.
close though.
Close? Yeah.
I'm one book away.
Yeah. One book away. Well, that's really close.
Does anybody else have any questions on this topic? Do you have any suggestions for next week? Anybody? Because we have a list.
Yeah, if anybody has any suggestions on the declaration, if you think there's something, some portion of law or some problem area that we've kind of left out, send me an email, let me know about it, because I am revising it all the time. Just like I put a section in for the DMV, I can put a section in for anything else that we feel that's needed. So if you have particular needs, maybe be with the retail stores in general, or the doctors. I mean, we probably should go after them as well. Look what they're doing.
That's what I was going to address really quickly, and maybe this is something we can talk about next week, but Ron, I would love to get your feedback on this. A lot of people are putting together power of attorney, in fact, where they're giving power of attorney to their loved one when they actually walk into the actual hospital, if they have to go in a hospital. I wouldn't recommend going into a hospital because that's, if you want to die, that's where you need
Good
to
place to
go.
go if you want to die.
Exactly. But I know there's certain times in which, you're in a car accident and you've got your femur bone sticking out the side of your leg. You should probably go to the hospital to mend that up. In the event that something like that happens, there needs to be proper paperwork between you and your loved ones. So that way you have someone to defend you. I literally saw a video, and I've heard nightmare stories, I'm sure you guys have too, of people walking in with their loved ones and they're being forced to either take this, fraudulent test, or they can't stay, or no test at all. They just won't let them stay. Right. So, and women that are pregnant. I mean, look, people are always giving birth to babies. And I personally, again, wouldn't recommend going to hospital. Imagine that, going to hospital, do that. But in some cases, if there's a breech birth, and the midwife doesn't know how to do this, there's certain circumstances where you need to
Well,
be able to go in there for a
Tony-
certain reason.
Tony could tell you about a recent experience going to the hospital. You want to speak up, Tony?
Oh, wait, we have a hand up.
Oh,
Allah?
you got a hand up?
Yeah, we have a hand up.
Oh, Tala,
Yeah,
how you doing?
I, maybe it's for next time. This is a question to Ron. Ron, you said that you became American in 1990s.
Yeah.
Can you share what did you do? I assume it's something different. I don't know, we don't have probably time today, but maybe
No.
for
Well,
future.
way back in the 90s, there weren't too many of us that figured this out, but I had figured it out. In fact, I came up with my own ID card or credentials. It's not in some ways as good as what we have today, but nonetheless, I made another copy of it after I got back because I had it before I went to Ohio, but they stole it. So I had to make a new one. And this is it, if you can see it. I just put my picture on there. It's got my regular ID, like a driver's license or something would, but I think the only number on there has to do with my bond number, if there is a number on here. Yeah, I think there is. Yeah, it's my bond number off my birth certificate.
So you made it yourself.
And so, yeah, I made it myself, and the back is a reduced down in size notary jurat. So it's notarized on the back, and it's like pretty much everything you need. But this was in the 90s I used this. But I was teaching law in the 90s, so I was going to the law library probably 2 days a week. Okay, I was still reading those books, but I way exceeded past 100,000. I don't know what the final total was. In Ohio, I read probably another 100,000 or better because I read not all of their case law, but I certainly read all the Ohio codes and learned them just like I had the rest, and reviewed the US codes and all that stuff. So,
Thank you.
Yeah.
Great.
So Ron, you're saying that you just knew you were on the land. You didn't
yeah, I knew I
correct your
knew
status
that-
or anything. You just knew
Yeah.
who you were.
Yeah, well, I mean, I gave notice. I don't remember. I was given notice every time I had anything come up. I'd give notice that I'm a man on the land, and this is my situation, and so on. You just talk the talk and walk the walk, and they got to respect it. I used to go to court all the time. I was in court almost every week for one thing or another. I'd go in for other people. I'd go in for me, and I'd stand outside the bar and be their lawyer. Now, the last time I went to a traffic trial, which I beat them senselessly, they tried to fine me $1, get me to agree to $1 fine. And I says, well, but there's $30.50 court costs. And, oh, you can't afford $31? And I says, no, that's not the point. The point is there is no facts to support a conviction here. I've already tore up your witness, which I did. I took the cop on voir dire for 4 hours that day. 4 hours of cross-examination. And he was squirming and trying to reach out to the prosecutor and get him to coach him. The prosecutor got sent to the back corner of the courtroom behind the gallery, behind the other people waiting for trial, and had to face the back corner with his arms folded, so he couldn't make hand signals. And I was watching him out of one eye while I was watching my witness with another. And see, all he did was he stated in the opening question, okay, can you state your name for the record? So he says, yeah, Officer David Jones, or whatever he said. Okay, well, that's okay. I'm not going to object. Then he says, and who do you work for, Officer Jones? He said, I work for the city of Santa Ana. Objection, Your Honor, facts not in evidence, voir dire the witness. Now, the judge knows what that means. Now, a voir dire is where you get to cross-examine the witness based on something he said. What did he say? He just said who he worked for. But is there only one city of Santa Ana? No, I named 7. Is it the corporation, the municipality, the municipal corporation, the business trust, the unincorporated business manager organization, the township, or this or that? I gave him about 7 possibilities, and this cop sat there and he looked as stupid as a box of rocks. He's like, and he's looking for coaching and help. And that's why when I saw the prosecutor trying to say this, don't say anything. Okay. Which he did have to answer the question. I made sure of that. But I had him on the witness stand for about 4 hours that day, I think, because the judge was, after about an hour at a time, the judge would get 4 times, almost an hour each. One time might have been 50 minutes. but most of them were right at an hour before I turned the witness back over to the prosecution, and the prosecution trying to run forward real fast and run the case forward. Well, did you on this day see him speeding down the street in this red car or something? Now, objection, Your Honor, facts not in evidence. And the thing was, he didn't see me, or he wasn't close enough to me to follow me, because he didn't come to the door of the liquor store I was in and bought a cold drink and a bag of potato chips after waiting for 2 other people to pay for their purchases. So I was in there for probably 10 minutes. And the guy walks up to the door at the end and says, "That's your red car parked in the back." Obviously, he couldn't have seen the car the whole time. He has to maintain contact at all times. I beat my first ticket that same way when I was only 18 years old. First ticket I appeared on, everybody ran out of the courtroom, wanted me to, be their lawyer. So I'm not an attorney. I can't do that for you. Now, if I knew you knew your case real well, if we had time to talk about it, I could do it. I'll stand outside the bar and do it. I've done it. Even in criminal cases. Because I know what I'm doing. And I'm not intimidated by judges. They don't intimidate me a bit. I see right through them. You can't be afraid of them. They'll see the fear in your eyes. They know how to manipulate you if you start coughing in. But when you know what to say, you know how to come back. And I'm not afraid to call a judge down off the stand, because I did that to the biggest badassest appellate court judge in Ohio that wasn't even supposed to be sitting on a bench trial. 88-year-old man, retired from the appellate court in Ohio. Most senior judge they had, his bar card number was 00005094. So he was under the 51st, 100th attorney in Ohio. He'd been there a while on the bench. And that man tried everything to get us to sign an agreement, and we lined everything out and initialed it, turned it in. He started ranting and raving when we did. And I saw the court reporter over there taking all this down. I says, "Objection, Your Honor. Facts not in evidence. You're not sworn in. So I want you to step down here, take off those black robes. I'm going to have this clerk swear you in. I'm going to void dire your ass." Now, you ought to have seen how red he turned. He turned purple. At least as red as your sweater, or as purple as your sweater. Oh, he was red, redder than your hair even, yes. And he was so embarrassed, and steam was literally coming out of his ears. And the prosecutor tried to object, and he sat there and started pounding that gavel so hard, I thought he was going to bust the handle off it, because he was hitting that table as hard as he could. And he's saying to the prosecutors, "You shut up, I'll handle this." The only thing he could do to handle it, because he didn't want to be void dired, he didn't want to take an oath and swear in, was that he had to dismiss the charges against me. That's what happened. Not that I wasn't injured in the meantime. So that goes into my judgment. Okay. Which it took a few years to perfect. We did back in 07. Anyway.
Nice.
So yeah, sometimes you have to know how to stand up to them, but you have to know about void dire. There's a few things that's good to know about. It's good to know your rights. And it's very hard to stand on your rights, because they will try and make you believe you don't have any, because they want to treat you as a U.S. subject. Well, I'm a man standing on the land, so obviously I have rights, unalienable rights. You can't take them away. Nobody can take them away. So I don't know where you think you're going with this, but if you think you're going to try and throw some evidence in here, without my participation or agreement, you were sadly mistaken. So I could shoot all the evidence down and put my own in. Go my merry way is what really happened. And that only took, that was, well, about 4 hours in court, both times, both with the traffic ticket and the big judge and nasty judge in Ohio, because it was close to noon. The jury was already calling up there several times, wanting to know why they weren't being void dired yet. Now, everybody knows about void diring a jury, but they don't let you void dire correctly under their rules. They set rules so you can't ask the questions you really need to ask. You're only allowed to ask a few questions and only get so far. And then they will seed the jury with attorneys, which are just evil as hell. They'll, and they work for the court. They seeded juries with all kinds of public service employees and things like that. They're not your peers at all. And I objected to every one of them they brought forward, every one of them. But we only allow you a couple objections, a couple cursory, this and that. But so sometimes you have to just take on the judge when you see him open up. So you have to pay attention. You have to know, you kind of have a mind for knowing what they're saying and where they're coming from. And the minute they open the door, you got to slam it right in their face. That's what I always did, and it always worked. So. Question?
Thank-
Jeannie?
Thank you, Ron.
Thank you, Jeannie.
You got so many good stories. So many good stories. We're so lucky to have you to learn from. That's for sure.
One of a kind.
Yeah.
One of a kind.
Okay, well, it's
Yeah, we was
7:40.
we was
Okay, so-
wondering about that. Why are they attacking me? I'm one of a kind. All I do is help people.
I know,
You want to attack the helpers?
I know.
You know where you're coming from.
Their loss,
Yeah.
our
they're
gain. So, okay, well, is there any more
Well, anyway,
questions?
yeah, we have there's lots of remedies if, and there's ways, and of course, we need to teach a lot of this in class like this or otherwise, so that you have some idea that there is a way to be able to talk to these tyrants, because they want to take that tyrant position and pretend like they own the place. They don't. Judges aren't supposed to be in those courts. They're supposed to be magistrates. And the magistrate's only there to, just like our justice, sit there and help people out and help run the court, not dictate terms and testify. So the minute the judge opens his mouth and says anything, he's mine. I own him because I can void diary him. And that is fatal to a judge. A judge will not take an oath away. So they have to just step down. It's beautiful. And believe me, it works. So good one for you too, Tamara. So remember that. You ever get in court, just wait for the judge to open his mouth and say something, and then take him on void diary.
Thank you so much.
And go and you go down, you drill down when you do this void diary. Like with the cops, he asked him, well, who do you work for? He said, well, the city of Santa Ana. Well, which city of Santa Ana? There are more than one. There's a corporate municipality, a corporation, a business trust, a this and a that, on a corporate, the township originally. Well, which one do you work for? And he's sitting there like this. He's trying to get help, solicit help from the prosecutor, coaching him. That's not allowed. He has to answer the question. So if you understand that, you really don't have any fear in the courtroom. There's nothing to really fear except fear itself.
That really makes it concise, because I think people get in there and their eyes start crossing and they
yeah.
start getting so intimidated.
Yeah, most people get
Um,
intimidated. That's what they try and do.
Mhm.
Yeah.
Thank you.
So why let them succeed?
Right.
You got to be a little bit smarter than the bear, right?
Just a little bit.
Yeah.
A little bit.
Thank you.
So, any other questions? I have lots of answers.
I think
Yes,
we'll get
no?
busy on a agenda for next week.
Yeah. Yeah. Okay.
I mean,
What are
we
you gonna,
have,
what are you gonna do
grand-
next week, Jeannie?
we've got grand jury. We've got,
Grand
I mean, we can go
jury.
anywhere. We can
Okay.
go
Yeah.
a lot of things.
Yeah.
So,
Yeah. The grand jury is the fourth branch of government, people, and don't forget it. They don't want to admit that, but it is. And all we have to do is get our 25 jurors together and we can go kick some butt.
Agreed. And I know we can talk about this another time, but there's already people that have all the evidence possible that they can take it past our grand jury,
Yeah.
and we can start the true bill and indictment process.
Yeah.
Yeah.
Needs to be done.
Yes, it does.
Don't do it this year. We better get on it first of the year. Start moving in that direction.
Jeannie, Ron wanted me to tell that story, what happened when I was in the hospital. Do you want me to say that to next week?
you can do it real quick. I gotta mute Ron.
I did.
Yeah, 'cause
I'm muted.
Okay, there. Go ahead,
Yeah.
Tony.
he wanted, it was mostly Tamara, he wanted me to tell you. Ron was here, going over his, document page by page. And it was going to all 50 states. And I'll try to make this real quick. The nurse called up. My doctor had done a test on my blood that day. The nurse called up and said, the doctor said you have to get to the hospital right away. I'll just say it. The doctor said you could die. Your potassium is critically low. I said, I'm not going. I have potassium here. I'll double up and I'll take it. Then I hung up. 10 minutes later, doctor's on the phone. Tony, you've got to go to the ER. You know how much I care for you, blah, 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 blah. And I'm, saying no, 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 no. And meantime, the ambulance is coming. Bottom line, he's on with 50 states. I go up, I'm waiting in the waiting outside in the lobby. And they were shocked because they thought I'd be like laying on the floor. I get to the ER, and the bottom line is this. They felt they had to take my blood themselves. Doctor walks in and says, I have to admit you. And here comes the nurse, ready to stick it up my nose. That test, I'm sure you know what I mean. And I said, I'm pointing to the door, like, get away. She goes, oh, I'll only go up to here. I says, you're not going up to anywhere. Out. Then I figured, well, they're probably not going to test me. I mean, not test me, give me the 3 bags of potassium. My potassium was really low. Well, they did give me the IV. They did give me the 3 bags of potassium.
Yeah, the emergency room.
Then, and by the way, they were all walking around like zombies. I felt like I was in zombie land. Then they had us change a shift. A male nurse comes in and starts taking the IV out. And I said, aren't you going to test to make sure I'm back to normal? And he says to me, well, if you would have followed doctor's orders, then you would have been checked. So in other words, they let me leave. I didn't even know if I was back to normal. I just said, the heck with them. It was 3 a.m. I called the taxi and I came home.
It's incredible the shit
Yeah.
that they are getting away with people that it, what does that have to do with the price of tea in China?
I did say to the doctor when he said that, I said, first of all, I was never inoculated and I never will be. And I said, and if you did, put me in the hospital, it would have to be a very, very private floor. A very, very private room on a non COVID floor. But, and that's when that, nurse came in with they let me leave, not even knowing if I was, normal. It really was sick. And they walked, the nurses, everybody, they walked around like zombie land. Their heads were somewhere else.
Only going to get worse.
Yeah.
That was it really was scary.
Are you able to order potassium bags along with getting there's a lot of nurses now that are wanting to do mobile IVs.
Mhm.
Are you able to get in touch with anybody like that to tend to your
If I
needs?
needed it, I could get home care. Yeah.
Okay.
That was because I was told I had congestive heart failure and your legs blow up. And I am on potassium, but he had given me a new pill. And for some reason, my potassium went critically low. And he was saying to me, you could die. But that's the only reason I agreed to go. I really didn't want to go near the hospital. But that's what they said. That's what they pulled on me. They let me walk out of there not knowing if it, was
That's horrible. That's
no,
horrible.
that was sick. It really was. It was a very sick thing to do.
I'm sorry to hear that, but that's the reality of the situation
Oh,
that's
yeah.
happening in the hospitals right now.
My son's new mother-in-law was crying. She was going to lose her job unless she took the jab, and she took it. And while they gave it to her, she was really, really crying. I
Mhm.
saw her for Thanksgiving. I saw Thanksgiving Day, and I gave her the list that Ron has to help break it up. He has that list.
Mhm.
The what is it? You probably know it.
Mhm.
I
probably have
walked
something
right.
similar.
I walked right over to her before I saw anybody else, because she's been in my mind for weeks. I want her, to take that, the ivermectin and all that. But she was crying, and they were, giving her the jabs because she wanted to keep her job. She was so worried.
A lot of people do just keep their jobs.
Crazy.
It's a terrible choice. You want to keep your job? Well, then you got to take this.
What they're saying is, do you want to die this way or do you want to die that way?
It's
That's
sad.
it.
Do you want to
That's
die of
it.
starvation or do you want to die of the jet?
I walked right over with that list and I said, you must take this.
Yeah.
My brother-in-law in Hawaii is in bad shape now because they took it. They were afraid they weren't going to be able to travel. And it started in his leg. He got, it started in his leg, went into his lungs.
I know.
I don't know about you, but I can live without it. Thank you.
Yeah.
The people where we live, they all think Ron's crazy because they were giving free
Crazy.
vaccines, and he ran downstairs with all the paperwork and everything. He had everything,
Crazy like a fox.
and he tried to stop it. Yeah, he tried to stop it, and now they think he's crazy, but they went ahead and did it anyway. He handed all the paperwork to the manager.
Yeah, the whole doc.
He said, "Read it." And guess what?
I had the whole
She read
dossier
it.
on the
She
fountain,
didn't get the inoculation.
129 pages.
And she quit the job because it's the senior building. And I'm getting out of this building anyway. I can't stand it.
That's another story.
That's another story. They're all gross.
Thank you for sharing that. I think that's really important I think everybody's aware of how bad it is, but at the same time, like when it hits home when it's very personal. I know
Yeah.
that there are a lot of good doctors out there and good nurses out there.
Yeah.
And us ourselves 2 years ago wanted to put a wellness center together and have wellness centers in every single state. And, there is a way that you can create that without having to be licensed and doing, business with the public, which I'm sure Ron knows all about. So, we're just, laying the groundwork right now for being able to do those types of things because, from what I understand, the hospitals themselves are a military operation.
Yep.
They're run by the military. So, the fact that this was Operation Warp Speed and vaccines have always been, this is not a vaccine, by the way, but
Well,
vaccines of the
I don't
past.
take the vaccine.
Yeah, they've always been an experimentation on the people when you really understand the history of it. So we really need to get back to Mother Nature and the things that she can provide for us, including just putting your feet in the ocean. That alone. I mean,
And,
not that's going to help your potassium problem, but
No, but just,
I'd like to say something about the teenagers. Do you know that it really is a cliquish thing? Because I was waiting for something in one of the stores and I was sitting there listening to a teen on the phone. And he was, actually, it was the pharmacy. And he was on the phone going like this. Yeah, I'm waiting. I'm going to get my jab. Did you get your jab? Yeah, I'm going to get it next. Blah, blah, blah. And this is the way they're talking. And they all want to get it because they want to be in the in crowd. And if they don't get it, they get teased. I mean, the whole thing has gotten crazy. And with the seniors, Gates, he said it in front of everybody. He said, us seniors, you probably heard it, are useless eaters.
Yeah,
So we should be just dead on the floor.
But don't they still make money off your bonds?
Mhm.
Yeah.
Yeah, probably.
Horrible.
Oh, they're making money.
Evil, evil, evil.
The problem
doctors-
is, Gene.
I know the people who do the numbers. They do all the figures. And he was standing right here. His two brothers do the figures. And the doctors do get $500 for every COVID marked. The hospitals were getting 30,000, and now they get 300,000 for every COVID.
Not a COVID death, just one. that
He
they
was
listed
an
COVID.
insurance man. It wasn't him, but he said his brothers do the books.
Yeah.
That's really sick.
Yeah.
The world is hopelessly corrupted.
Mel has her hand up.
If it is
Yeah.
to be, it's up to us. Hi, Mel.
Hi, Mel.
Hi, another quick question. I know we're trying to wrap it up, but a couple weeks ago, James on Sonoma mentioned a website where you can follow court cases. I wondered if anybody could remember what he said. It was some kind of website where, you know, right now, if we actually go through the court, they want us to pay $1 each time we inquire about a case. So I don't want to give him anything, so I don't want to pay him $1. But I didn't know if anybody remembered what James had said, or I don't know, way to contact him possibly.
No, follow your court case. What was
Yeah,
that?
there's some kind of website where you can follow a case and it'll notify you if there's anything entered into the case, either from your side or from the other side, or if there's like a update to the case.
I'm sure Lincoln will know, so I will find out.
Okay. Actually,
Well,
I'm supposed to talk to her tomorrow morning at 10 a.m. So
Okay.
I can ask her then too and share with the group next time. Where is she anyway? Why isn't Lanka here?
Well, it could have been because it was last minute, so.
Oh, yeah. Well, I'm glad we're back, and I'm definitely glad we're going to be consistent. So thank you for setting that up. And do we know about the land patent? I know we were on Thursdays. Are we still doing a land patent
Yes.
committee?
Susanna said yes.
That's Lincoln.
Yeah, Susanna and Lenka said yes. I think Thursday is Land Patent 101, or is that, anyway, it's on our website, but I am on 101.
Yeah, last week there was supposed to be a 101 at 10 a.m. I found out about it. No, it was supposed to be on Friday because I saw everybody on Thursday at Linka's event, and then they were like, tomorrow morning at 9 a.m. there's a 101 land patent call, but then that was like, it said something like October 22nd and the link wasn't working. So is there still a 101 call on Friday, or are we just sticking to the Thursday?
Mel, there was a 101 class a couple weeks ago, and I have the recording.
Ooh,
So I can send you the actual recording of the 101 class.
okay, that'd be great.
And then
Thank you.
I still need to breathe. Oh my God, my sick dog is snoring.
Oh,
Oh my gosh. Okay, so 101 class to Mel. Because I've sent that out to a few people, and then we can all get kind of up to speed on everything, and then hook
Great.
into the rest of the land patent class. So,
cool.
okay,
thank you.
thank you guys. Thank you all.
Thank you,
Next week.
Tamara.
Thank you.
Thank you, Ron. Thank you, everybody. Much
Thanks,
love.
Jeannie.
Thank you.
See you
Thank you
Thursday.
guys. Thank you guys.
Thank you, everyone.
All right.
Much
Good night.
love. Good night.
Night.
What do I do? Are you out? I'm out. Bye.